The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. Welcome to the United States Court of Appeals for the Fourth Circuit. We have three cases on for argument this morning. First up, 23-4467 and 23-4587, United States versus Jackson. Mr. Abrams, whenever you're ready.
Good morning, Your Honors. May it please the Court, my name is Elliot Abrams, and I represent the appellant, Dr. Anita Jackson. In this case, the federal government created and then enforced its own standards of care with respect to the use of certain medical devices. It did so in contravention of the plain language of the statute and in violation of the purpose of the act. It did so without consulting medical authorities, and it did so using the full coercive power of the federal criminal law. Each of Dr. Jackson's convictions and her 25-year sentence should be vacated, and the adulteration charge should be dismissed or a judgment of acquittal entered on that count. The first reason that the adulteration charge should be is defective is that a doctor or any medical provider does not hold medical tools for sale when they use them in the provision of a medical service.
So in this service, though, if I understand the record, one of these devices would be used for a sinus operation, and the doctor would bill Medicare or Medicaid for that instrument.
No, Your Honor.
And they not? I thought she said she made $1,200,000 off of billing for using the same devices.
No, Your Honor. So at JA 997, 1059, and 1064 to 65, the lead agent for the government testified that Medicare pays for the service, not for the device. He testified that Medicare doesn't have restrictions requiring certain devices to be used for the particular service being billed for, and he testified that there's no line item on the bill that Medicare is paying for.
Well, somebody's got to be paying for the device. How does that work?
So the doctor is paying for the device,
right?
But the service itself does not require this device. It doesn't require a single-use device. It just requires the words of the CPT code say a balloon sinuplasty device or other device. And that issue is also discussed at 1418 to 1419.
But there's no dispute that this device was the one being used in most, if not all, of the procedures, right?
She used this particular device in most, if not all, of the procedures. I think the issue is that she didn't bill for the device, just like a roofer doesn't bill.
Well, but that's because the cost of the device, I think it would be incorporated in this service, wouldn't it?
It could be, just as a roofer's tools, like a roofer's hammer, could be incorporated into their provision of, the service of redoing my roof, or I bill.
But they're not billing Medicare or Medicaid for that.
They're not, Your Honor, but they are billing, doctors bill people as well. And so, this issue of, it's a fundamental question of whether a physician holds a device for sale when they provide a service. And our contention is just like a roofer doesn't hold a hammer for sale, just like lawyers don't hold ink pens for sale just because they use them in providing their legal services, medical service providers don't hold their tools for sale when they provide services. And the Supreme Court in Sullivan said that this term, held for sale, is unambiguous. And then it tells us what the term means. It says it's held in anticipation of a purchase, and it didn't use the word purchase, excuse me. It says held in anticipation of having the device pass into the hands. So that's the quote, pass into the hands. And then I'm saying that means it's purchase, because then it uses the word by way of a transaction. So in Sullivan, the Supreme Court says it's an unambiguous term. It tells us that the term means what it unambiguously means. Now, I'm asking this court to apply that unambiguous plain language for a number of reasons. And one of those reasons is really important here, and that is that under 21 U.S.C. 360K, the FDCA contains an express federal preemption provision. That provision says it says states and any political subdivision of a state is barred from imposing different or additional restrictions on devices.
Before we get too far down this road, one of the things I neglected to ask early on was, what do you contend the standard of review is for this claim? Because there are all kinds of allegations that from the government or assertions that most, if not, I mean, the ones that matter anyway, the assertions weren't properly preserved. So what's your position on that?
Our position is that this was absolutely preserved, Your Honor. When you look at the ruling that we've appealed from, the district court says, I'm finding that this indictment states a claim based on Kaplan. And the issue in Kaplan is the issue here, the held for sale
Yeah, I mean,
issue.
Kaplan was about a great many things, and beyond saying that he's deciding the case based on Judge Dever, I think, deciding the case based on Kaplan, it doesn't really focus on this particular issue, nor did were you the trial counsel?
I was not, Your Honor.
Okay. Nor did the lawyer focus the court's attention on this particular issue. Do you agree?
I agree that the briefing did not raise the Kaplan issue directly. There's a number of different reasons why the court
So
was
are
on
you talking
notice.
about whatever your briefing was in the district court, your argument to the district court, or the briefing here?
District court, Your Honor, both the briefing and the argument. There wasn't a hearing that went into all this, so looking at the briefing, what we have is a motion to dismiss for failure to state a claim. We have the judge then saying, I find that the offense states a claim because I'm looking at Kaplan. And the issue at Kaplan was the issue here. And so the court, this is a very careful court, as all courts
The bottom line
are.
issue is that how did you alert the district court that its decision was incorrect?
So rather than approach it that way, Your Honor, the way we're asking the court to look at the preservation issue is the fact that when a court makes a ruling and that ruling is legally erroneous, that ruling is appealable. And here, the court said, I'm upholding the indictment based on Kaplan. The holding in Kaplan is that these things are held for
Did you
sale.
discuss that case prior to the district court's ruling?
No, Your Honor. And the district court noted that neither side raised this and said, I've found this issue, and I'm saying that it states an offense based on Kaplan.
And you say the Kaplan case was all about this held for sale, but Kaplan dealt with a number of issues, 5, I think, by my count.
And the issue that is relevant to this case, that would have been relevant here, is this held for sale issue. And there's a lengthy discussion at page, in cases we cited at page 15 of our brief, where this same framework is used to say, look, when the district court shows that it was on notice of an issue, it clearly read Kaplan, that you can appeal the legal ruling because the district court had an opportunity and took an opportunity to address the issue. And these are pure legal rulings, so it's not that, I think it's somewhat different, for example, than a factual situation where you've got to let the district court do its own evaluation. Here, y'all are in the same position as the district court. We can all review the words held for sale. We can all review the case law. We can all review the indictment and just say, does it state an offense? And so this court's in no worse position because of the district court. It's or because of this not being detailed in the briefs. We did 100% raise the legal claim that this count fails to state an offense, and the court relied on Kaplan in rejecting that. So we believe under the Dusorio line of cases and just the rule for preservation that we've
Do we have to
Yes,
find
sir.
that Kaplan is wrong in order for you to prevail?
Yes. I'm asking this court to go against Kaplan. In fact, the government's really not fully embracing Kaplan. The government wants this court to go beyond Kaplan and say that doctors hold all devices for sale, whether or not they're labeled as single use. So there's neither party up here saying Kaplan got it right. We're saying Kaplan got it wrong. The government's saying Kaplan didn't go far enough.
But if we happen to agree with the district court, just for purposes of argument, that Kaplan was correct, we would have to say Kaplan was wrong in order to find for you.
That's correct, Your Honor. And I think Kaplan is wrong for a number of reasons, one of which is there's people don't use the term held for sale when they're talking about the tools of providing a service. And Justice Scalia, then as a D.C. Circuit Judge in Cheney, says this is not what this term means. He provided a detailed analysis of the absurdity that would result, saying, I'm going to quote from the Cheney dissent, which was ultimately the Supreme Court reviewed the case and reversed the D.C. Circuit. He says, given the statutory language held for sale, it's clear that when the House report said that the intent of the 1983 amendment was extended to the protection of consumers contemplated by the law to the fullest extent constitutionally possible, it was using the word consumer in the sense of purchaser rather than ingester. And then he continues to say the consequences that would ensue from this interpretation that held for sale means held for use by a doctor are implausible as the interpretation that produces them. It cannot be seriously thought that the householder who places a drug in an unmarked bottle on his medicine shelf to administer later to his child violates the criminal provisions of the FDCA. That would be the result in this case if you say that held for use means held for sale, because a doctor who takes a package of tongue depressors and then puts them into an unmarked jar violates the misbranding and adulteration provision at issue here if it applies to them. You're not allowed to remove a label from a device. You have to store it in a particular way. And so all of the FDCA is about, and the Supreme Court in Buckman says this, there is a specific quotation in Buckman, and I apologize for not citing it in my brief. I found it 2 days ago. It says let me find it right here. It says that the FDCA is about regulating marketing and distribution, and then it uses the quote, not use of devices by physicians.
So we don't lightly ignore anything that Justice Scalia has to say in most things, but that was a dissent. The D.C. Circuit felt otherwise, and I think there are at least 3 other circuit courts that disagree with you. So what are we to make of those decisions?
So none of those, there's only one case here. It's the Diapsal case, 1975, Second Circuit. It's like a one-sentence per curiam opinion that actually addresses devices. The others address drugs. Drugs are different. Drugs, for example, returning to the roofer analogy, if a roofer comes and reshingles my house, maybe I purchased the nails. They stay with me. I have the title to the nails. I've got the title to the shingles, but I don't purchase the hammer. Drugs, I ingest. But the devices, I don't keep. I don't have the title to them. And so the drug analogy is not the appropriate analogy, and the drug context is what all of those cases, except the one 2-sentence case that's a drive-by ruling that wouldn't be precedential in this circuit because it has no analysis. So there's not this whole body of case law on the government side. There's Kaplan. Kaplan misread, and Justice Scalia says that one of the cases that the Kaplan court relied on is wrong. And so you've got this whole issue of if you just use the plain language, which is what we do when we read statutes, unless they lead to an absurd result.
What difference would it make? You will probably say it doesn't make a difference. We're not dealing with an adulterated hammer or an adulterated nail. We're dealing with an adulterated medical device. So how does that impact this held for sale concept?
It doesn't, because it's a threshold question. If it's held for sale, then the FDCA regulates it, and under this preemption provision, then the states can't regulate it. And that's why I asked this court to really look at 360K, because it's if you break it, you bought it situation. Once the federal government regulates something under the FDCA, it preempts the states from doing it. And so in the Kaplinger case, which I cite repeated throughout my briefing, it's a Justice Gorsuch case when he was with the 10th Circuit, the dissent there talks about this issue and says, that practitioners are not covered by these rules. It says the prohibitions against misbranding or adulteration do not limit the ability of doctors to exercise professional judgment in their use of approved devices. It says, however, state tort remedies such as malpractice ensure those practitioners employ devices in line with professional standards of care. You would upset the balance. You would take away from the states the ability, potentially, to regulate doctors' use of devices because it's preempted for states to have different or additional requirements. And so it's not just, let's add this protection to consumers. It's who's in the better position. And really, it's who did Congress want to do this? And I know my time's running out, but Congress, as the U.S. Supreme Court said in Buckman, Congress wanted the states to regulate the doctors and wanted the federal government to regulate the marketers and the distributors.
Thank you, Mr. Abrams.
Thank you.
Ms. Allen?
Sorry. Thank you, Your Honor. Catherine Allen on behalf of the government. I would like to start with the standard of review. In this case, Jackson did not challenge the held for sale element of the offense when Jackson challenged the indictment. She challenged the indictment on 3 grounds. She challenged the standard of adulteration as unconstitutionally vague. She challenged the allegations regarding intent to defraud or mislead because she argued that sterility, the word sterile was also vague, and she challenged the intent to defraud or mislead element on the ground that this was off-label use. Now, none of those challenges involved held for sale. The district court then rejected her challenges to the indictment and did cite Kaplan. And as Your Honor noted, Kaplan addresses a number of issues, including 2 of the issues that she did raise in her motion, and that is the intent to defraud and mislead element, as well as off-label use. So I don't think that the district court's invocation of Kaplan when it was rejecting the challenges that Jackson did make in any way indicates that the district court was considering the held for sale argument. And the district court in this case issued very thorough oral and written rulings, and the held for sale element isn't discussed at all.
So your view on this particular issue is that it's plain error review?
That's correct, Your Honor.
And, well, if the district court had in fact considered the issue, even if the defendant had not raised it, and we have cases that suggest that in that instance, we don't apply plain error review, right?
That's correct. And in the case that Jackson relies on in her appellate briefing, I apologize, I can't remember if it was from this court or not, but the Court of Appeals stated that the district court had thoroughly considered the issue on the record. And that's really a far cry from what we have here, where there's nothing in the record discussing the held for sale element. And we think that Jackson hasn't shown that there was any error with respect to the court, to the interpretation of held for sale here. And she certainly hasn't established that any error would have been clear or obvious. And that's because every court to consider this issue has held that when a doctor holds a drug or device for use on treating patients during treatments that are sold to patients, that those drugs or devices are held for sale within the meaning of 331K.
Well,
and that's
counsel cited the record, which I'll have to say I had not seen before, and got the contrary impression from reading the district court's opinion in the briefing, that when the physician bills Medicare, Medicaid, they aren't identifying this sinuplasty device on the billing. Is that correct?
It's correct that it's not an itemized billing. There was testimony, but I don't think counsel's suggestion is correct. So the testimony that's at issue here with respect to the way that Medicare is billed is that there are certain procedure codes that a doctor uses to bill Medicare, and that those procedure codes include the cost of the equipment that the doctor uses. And I can point the court if you'll just give me 1 second, to the specific. At trial at JA 1403, there was testimony that part of the amount reimbursed takes into account covering the cost of the equipment for the surgery, and that it was that Medicare pays the same amount as when an individual pays for, quote, that surgery and that device out of their own pocket. And again, on redirect.
Who was testifying there?
Quindoza, and he was testifying about how Medicare billing works. So I think that there is evidence, and again, we're here after a judgment of conviction against Dr. Jackson. So all of the evidence has to be taken in the light most favorable to the verdict. And here, I think if the court looks at JA 1403 to 1404, it's clear that there was testimony that the cost billed to Medicare includes the cost of the device. And again, just stepping back, Jackson relies on Sullivan, and I think the Supreme Court's decision in Sullivan supports the government's interpretation here. In Sullivan, the Supreme Court held that Section 331K was added to the FDCA in order to ensure that drugs and devices, that drugs were regulated from their point of manufacture all the way until the time that they reached the ultimate consumer. And that's exactly what happened here. And I would also urge the court to look at the Hippolyte Egg Company case. And in that case, the Supreme Court rejected an argument very similar to the argument that Jackson's making here. It involved the phrase "for sale," and in that case, the argument was that the eggs that were shipped in interstate commerce weren't going to be sold by the bakery. Instead, the bakery was going to use the eggs as raw materials. The Supreme Court rejected that argument and held that those eggs were within the scope of the predecessor to the FDCA because they were not for personal consumption. And so I think just in the same way here, as the devices, the balloon sinuplasty devices that we're talking about are still in the stream of commerce. And the way that they reach the patient is through the doctor's sale of those services. And again, every court to consider this issue has agreed with the government's interpretation. And I would also say Jackson suggests that we're somehow walking away from Kaplan. We've explained in our brief that the government does that our view of the FDCA and its regulation of devices extends beyond just single-use devices, but we're in no way disagreeing with Kaplan's conclusion that single-use devices are covered under the FDCA. And again, here, the government's point is that when we're talking about the FDCA, which is a comprehensive scheme that regulates drugs and devices from the point of manufacture until they reach the ultimate consumer, which here is the patient, that the FDCA treats drugs and devices that are stored in a warehouse the same as it treats drugs and devices that are stored in a doctor's office. And we don't think that Jackson has shown any error here, much less plain error. If I could just, I also just, Jackson has argued here that drugs should be treated differently than devices because drugs are often injected into a patient. And as we noted in our brief, devices can be implanted in a patient as well, pacemakers, artificial valves, artificial joints, and there's no reason that that Congress would have treated those any differently than devices such as the one at issue here that are being inserted into a patient's nose. And lastly, just to respond to Jackson's other argument suggesting that it's going to somehow upset the balance of power here, I would just want to reiterate that since the Supreme Court's interpretation in the Hippolyte Egg Company in 1911, all the way through Sullivan and all of the Court of Appeals cases, all of those cases have viewed the FDCA in the same way that the government is arguing here. And so I don't think that this court siding with the government's interpretation of held for sale would in any way upset the balance that has existed for many, many years. If there are no further questions.
I have a question about the per se jury charge. And I noticed in your brief, are you all conceding that the judge gave the incorrect charge?
Absolutely not, Your Honor.
Okay.
Sorry.
Go ahead.
So the judge, Jackson's argument regarding the alleged per se theory goes to the standard for adulteration. And here, the district court quoted in the jury instructions, it instructed the jury that to find Jackson guilty of adulterating medical devices, it had to find that she had held the devices in conditions that may have rendered them in insanitary conditions that may have rendered them contaminated with filth or rendered injurious to health. The court then instructed the jury that the terms filth, that the term filth should be given its plain and ordinary meaning, understanding. And so there's no way that the jury could have found found her guilty based on those instructions, based on a per se theory. And I also just want to point out that the government, this case would look entirely different if the government had been pursuing a per se theory. The government's theory in this case, from the indictment through the proof at trial, has always been that the particular facts of this case satisfy the standard of adulteration and show that these particular devices, because of the way in which she stored them, the fact that she wasn't cleaning them properly, there's also testimony about that the devices looked yellowed or they had rust or the balloon portion wasn't sliding properly on the device. There was a lot of evidence at trial, and there are similar allegations in the indictment to meet the statutory standard for adulteration. And again, the jury couldn't have convicted her under the instructions that the court gave without finding that that statutory standard was met.
Even though opposing counsel didn't get to it, if I'm remembering this case correctly, there was also an issue raised as to an improper golden rule argument. Why don't you just give us a short explanation of your view?
Sure, Your Honor. So that argument wasn't raised in the district court, and so it should be reviewed by this court for plain error. We don't think that Jackson has met the prongs of the plain error standard here. She hasn't shown that there was any improper golden rule argument. It's true that the government counsel did use the word "you," but the government was not in any way asking the jury to convict if they would have was not asking the jury to convict her because but the government used the word "you," but that was in getting the jury to use their common sense to determine whether patients would have viewed it as material, whether she was properly cleaning these devices.
But wasn't he or she, I don't know if it was he or she, asking the jurors to put themselves in the shoes of the patients who were being subjected to this procedure with this adulterated device? Isn't that a classic golden rule argument?
I don't think it was a classic golden rule argument, Your Honor. I think what the attorney was doing was asking them whether they would want a clean device or not, and that was to illustrate. And then the attorney then brought it back to the question of the patients. And here, all the government attorney was trying to do.
So that was a mini golden rule argument, a truncated golden rule argument.
I don't think so, Your Honor. I mean, the attorney was trying to ask the jury to use their common sense in determining whether it would have been material to their decision whether to have the surgery.
That's a good argument, but he didn't say that, or she didn't say that. She said, would you want a doctor to use that device on you?
Your Honor, and then the government was just explaining why the choice between a sterile device and a possibly contaminated device was material. And it's fine. There's no clear or obvious error here with respect to.
Well, that may be your argument, I suppose, but whether or not there was an error, I think is a closer call. It may not be plain, but.
I don't think that there was an error here. Again, this all needs to be considered. When you look at the argument in context, she plucks a few statements here and there out of the argument, but the attorney brought it back to the correct legal standards and to the question of these patients, referred to all of the patients that had been before the court and the testimony about whether they were given that choice between a sterile device, or whether they were given the choice to have a sterile device. So again, the attorney brought it back to the correct legal standard and to the question of whether the patients here would have had that choice and whether it would have been material to their choice. So I don't think that there was an improper golden rule argument. But again, I also I don't think that she satisfied the plain error standard here. And I would point out, she argues that plain error doesn't apply, but the case that she relies on is one in which the attorney did raise the argument right after the allegedly improper golden rule argument and in a motion for a new trial. And here, Jackson didn't raise the argument at all in the district court. So we think, relying on the cases, United States versus Husky and the other case that we cited in our brief, that it would be reviewed for plain error.
And they also bring, or she also brings up this issue with Dubin, in this argument that it was overbroad, that I believe the jury charge and the indictment was overbroad. And so I guess my question is, how is this case distinguishable from Dubin in this crux of the fraud analysis?
Sure, Your Honor. So Dubin involved a very different situation than here. In Dubin involved Medicare fraud, and the fraud that was at issue was that the defendant was overbilling for a psychologist services when it wasn't actually a psychologist who was performing the work. And so in that case, the fact that when the defendant submitted the bills, he used a patient's name, that was ancillary to what it was that made his conduct fraudulent. This is a very different situation. Here, we're talking about classic identity theft. We're talking about a declaration in which the person who signs the declaration, on the face of a declaration, it states that I, the person signing this, am attesting to the following facts. And she and her employees were forging patient signatures and backdating those declarations. So what made those declarations false was the forged signature. And so it goes directly, the use of the identity in this case goes directly to what made them false. It wasn't an ancillary use of an identity where the falsity had to do with who the provider was. Here, the falsity had to do with whether or not the patients had signed the declarations, and they hadn't. So this is a classic case of identity theft. The Sixth Circuit and the Tenth Circuit, as we cited in our brief, found that in similar situations, there was any error was harmless because it was a case of classic identity theft. We think that there was no error here and it was harmless. So we think the same analysis would apply here.
Thank you, Ms. Allen.
Thank you.
So if I may start with this golden rule argument, I think it informs two issues. The first is what Dr. Jackson was actually charged with. The government in its brief at 34 says it doesn't matter that she reused the devices. They're running away from the charge in this case.
So are we using plain error here?
No, the government concedes that this issue was raised below, that the concept of the charge not stating an offense because reuse is not.
No, I'm asking about the golden rule argument. I thought that's where you started.
So the golden rule argument, it wasn't raised below. We've cited the Leathers case that says you don't have to object. And so the court can decide whether that means you don't have to object ever in the district court or just not right when the argument is made. There is
But you never objected.
Not in the district court, Your Honor. But we did object to the indictment not stating an offense because it was based on reuse, not actual adulteration. And the government says now, look, the indictment, it doesn't matter that she reused. But if you look at this is the second page of the indictment. It says what the crime she's charged with, reuse of single-use devices. Now they're saying that doesn't matter, that it just matters that the devices weren't clean. The entire record below shows the district court thought what mattered was she reused devices that were labeled as single-use. It prohibited her from testifying that the devices were not contaminated. It said repeatedly that that was irrelevant. It said that at 3157, she testifies, and then 3161, 3167. She's trying to say what she did, which is she tested these devices after she cleaned them. How can they be adulterated if they're clean? They can't be. Well, it doesn't matter according to district court. It's irrelevant according to the district court because she's not charged with not sufficiently cleaning them. She's charged with what it says in bold and underlined on page 2 of the indictment, reuse of a single-use device. That is not what the government defends now. That was raised below. It's not a crime to reuse a single-use device. It's just not. The government doesn't say it is. And so when you look at this case, I spent too much time, I guess, on the first issue. That issue, they can't overcome that. They have to try to change the indictment to meet, to uphold it. The indictment says what it says. They can't amend it. And they try to amend it at page 34, saying it's irrelevant that she administered the devices. How can that be? That's just not what the law is. And then they say, no court has gone our way. That is absolutely incorrect. If you look at the Kaplinger case, if you look at the concurrence in that, It says the adulteration provision does not apply to physicians' use of devices. If you look at the statute, 21 U.S.C. 396, it says physicians' use of devices is not covered by the FDCA. This whole case was Dr. Jackson's use of a device. That's statutorily protected. So the government has to do what it's done and say, wait a minute, this isn't about use of devices. This is about insufficient cleaning. If that were true, she had to be able to introduce the testimony that she tested the devices and they were not contaminated. No patient was harmed, none. The court repeatedly said it's irrelevant whether patients are harmed.
Can I ask you about, when you say she should have been allowed to present the evidence with respect to cleaning and testing, she did talk about that, didn't she? It was the video that you were, do I have that right? That's what you're referring to, the video that wasn't allowed into evidence?
Yet she talked about her cleaning, and then the jury is told it's irrelevant. It's irrelevant that they're not contaminated. At 360, 3161, 3167. I mean, the question is, was there any issues with complications or cross-contamination? Objection. Sustained. Ladies and gentlemen, the United States, in connection with count 1, does not have to prove that a single patient got sick. Well, of course, if someone had gotten sick, that would be evidence that the devices were dirty. And so the converse is true as well, unless you are adopting what was charged in the indictment, and that is single use.
I thought a lot of her employees testified that they were filthy.
It's not that there's not evidence in the record of whether they were dirty.
I think there are pictures.
Well, and the pictures are taken, respectfully, the pictures are taken months and months and months later. She had shut down the office. The pictures have nothing to do with the condition at the time. And so, this issue is that the district court told the jury, don't listen to evidence about whether they're actually dirty. That only makes sense if you're applying the per se standard, which is what is charged in the indictment.
Well, what you just said, though, was that the district court prohibited any, or didn't think it was relevant that anybody got sick. Those are two different things, right?
But here it says, did you have any cross-contamination? No. Objection sustained.
And what was the basis, what did the district court then say?
Ladies and gentlemen, I'll just remind you again, it's irrelevant. It does not have to prove cross-contamination. Cross-contamination, they don't have to prove it, but of course it's relevant if the issue is were they dirty. If the issue is you use single-use devices, it's not relevant. And so she wasn't allowed to defend herself on the fact that she actually cleaned the devices and they were therefore not dirty and not adulterated. And so she has to get a new trial, not on just this count, but all the counts. And if the government cites the Jefferson case, it does the perfect analysis. It says, you got to go and see, is there any reasonable way a jury could have acquitted her? And a jury could have acquitted her on all the counts if they were properly instructed, if she were allowed to say, here's my cleaning process and it worked. I tested all these devices. They were not contaminated. Nobody got sick. I'll show you how I did it. She wasn't allowed to do that. And so the jury was told she is a corrupt doctor because she reused single-use devices and you're not allowed to reuse them. That's not true. The government doesn't defend that theory. They just say that's not the theory. But that's what this trial was about. And once the jury hears she's doing something in clear violation of the law, which is not correct, of course they're going to judge her credibility differently. Of course they're going to think that she intended to defraud as it relates to the other counts. And so she has to be able to go in and say, here's how I cleaned them. I did it well. I tested for cross-contamination. I was a careful doctor. Not, you violated some law that doesn't exist, that you can't disregard the cleaning of the label. You're allowed to do that. The statute says you're allowed to do what she did. She asked for the jury instruction on that. It was denied. She asked for a jury instruction saying it's not a per se crime to reuse a single-use device. That was denied. She was not allowed to defend herself by walking in and saying, I cleaned these things. They're therefore not dirty. I tested. They're therefore not dirty. She wasn't allowed to do that.
You're 2
Thank
minutes
you.
over your time. Thank you very much.
Thank you.
Thank you both for your arguments this morning. We very much appreciate it. We'll come down and greet you and then move on to our second case. Our second case is 24-1054, 3074 Centreville LLC versus M.A. Cohen and Company. Mr. Doble?
Good morning. May it please the court. Gabriel Doble, representing the appellants, Mr. Cohen and his company, M.A. Cohen & Co., Inc. The district court's summary judgment ruling should be reversed. I'd like to start with the breach of contract claim and then move to the quantum merit claim. When parties orally express agreement on material terms with the intent to later reduce their agreement to a formal writing, disagreements over the terms of the formal writing do not negate the existence of the initial oral contract. California law is very clear on that point.
So did any of the written agreement drafts recite the existence of an oral agreement?
No, they don't, Your Honor. And that's because the parties understood that they were reducing their oral contract to a written agreement. It's not required for the written drafts to refer to an oral agreement for there to be a separate oral agreement. That doesn't show as a matter of law that there was no oral contract.
Certainly would have helped your case if they did.
I agree it would have helped our case, Your Honor, but that's an issue for the jury to decide.
How do you reconcile that, even being, Mr. Cohen being represented by counsel and references to counsel in this back and forth correspondence and no mention by counsel of any oral agreement?
Most of the parties' conversations, Your Honor, took place orally, in oral conversations. Those were their discussions over the terms of the contract. The email correspondence was pretty much just sending drafts back and forth. And what the district court did here in relying on that exchange of written drafts to show that there was no oral contract as a matter of law was it thought that the exchange of written drafts blatantly contradicted Mr. Cohen's testimony, which established the existence of an oral contract. And that's exactly what California law says you can't do. The California Supreme Court in the Patel case said that subsequent disagreements should not be taken as evidence that no initial contract was reached. Now, Mr. Cohen's testimony is that in April 2017, the parties met and they orally expressed mutual assent to terms that were reasonably certain. That testimony has to be credited at summary judgment. The district court didn't credit that testimony. It disregarded it. And the reason it thought it could do that is because, in its view, the exchange of written drafts blatantly contradicted the existence of an oral contract. It thought that because the parties exchanged written drafts with additional and materially different terms, that showed that no oral contract existed as a matter of law. But that's exactly what California law says you can't do. It happens all the time that parties reach an initial oral contract and then attempt to reduce that contract to a formal writing and disagree about the terms of that formal writing. For example, because one party tries to insert a term that the parties never agreed to in the first place.
So what do you say was the final oral contract that the parties agreed to? Because there were a number of discussions in April and then in October, and there were there are differences, right, in those conversations. So what is in your view, the final oral contract here?
The final oral contract, as a result of the November modification, was that Weber would give Cohen a 20% profit participation interest in the Herndon property and in future properties that his business acquired, and that Cohen would accept that 20% interest as compensation for his past 8 years of advisory services and for the advisory services remaining to eliminate the Herndon debt. That was a modification of the April 2017 contract, which had the same terms, except rather than a profit participation interest, it was an equity interest. And to
So
be-
am I remembering the record correctly that at some point later, after this November discussion, that Mr. Cohen sent a proposal for a 25% profits interest?
That's correct, Your Honor. And I think this is part of where the district court got a little bit mixed up on the facts. That 25% was a proposed modification as a result of new information that the parties learned after they already entered their April 2017 contract. That new information was that another guy, Mike Michaels, was bowing out. He was not going to accept his 20% interest. The parties learned that, I think, early fall 2017. And so then Mr. Cohen proposed, okay, how do we divide up this extra 20%? Let's give 5 to me and 15 to you. So let's say 25-75. Weber said he'd think about it and that Cohen should send a draft reflecting that proposed change. So that's what Mr. Cohen sent. Afterward, when they discussed, Weber said, actually, I want to keep your interest at 20%. And so that's what the parties agreed on, that it would be a 20% profit participation interest.
And that was in return for two things. One, the past work that was done in support of the Herndon financing, or maybe even more work, which, if standing alone, do you concede that that would not be sufficient consideration because it was for past services?
No, I don't, Your Honor. The rule is that past services are only insufficient when the consideration goes beyond the party's existing obligation. Back in 2009, when the parties met, they agreed that Mr. Cohen's advisory services would be compensated with a percent interest of the business if and when it had value. So all of Mr. Cohen's work during those 8 years was done with the mutual understanding that that work was going to be compensated with a percent interest. By agreeing,
Did they know what percent interest from your standpoint?
they hadn't decided that in 2009. That was the point of the 2017 conversation, once the business had value.
Well, standing alone, then, that's not a sufficient oral contract, right? Without that number, that's not an agreement, oral or otherwise.
We're not relying, for this appeal, we're not relying on the 2009.
I know you're not, but you're relying on it now to say that because of that, there's an exception to the past, consideration rule.
Right, so regardless whether there was an actual contract in 2009, Mr. Cohen performed those services with the understanding that they would be compensated with a 20% interest. So at a minimum, he had a claim for quantum merit. Giving up that claim for quantum merit is consideration for a contract. When a party gives up a legal right, that's consideration. That's why settlements are enforceable.
So that part of your, maybe I'm misunderstanding. Are you saying that the services between 09 and 17 comprise the quantum merit portion of your claim, or do you say that's independent consideration for the 2017 agreement?
That's independent consideration for the 2017 agreement. The quantum merit part of our claim is in the alternative if the jury finds that there was no oral contract. But Mr. Cohen accepting.
Why wouldn't that be an agreement to agree? I mean, if you don't know what you're going to get, I'm not quite sure how that can be a valid contract.
Well, we're not saying that the 2009 agreement was a valid contract. We're focused on the 2017 contract in which the parties described precisely what they were going to get. Weber said, if you finish up this Herndon deal, I will give you a 20% equity interest in my company. And that would be compensation for those 8 years of past services and the services needed to eliminate the Herndon debt. Cohen
And you
said,
say, when you say if you finish up the Herndon deal, but what was the $150,000 for, if not for payment for finishing up the Herndon deal?
that was for the loan brokering services that Mr. Cohen.
Well, what beyond loan brokering do you say that he did?
Well, loan brokering comes in only at the very end of the process. It happens once you've got a property tied up, a contract, a purchase price, you know the loan amount you need. Then you go out and hire a loan broker. And the loan broker identifies potential lenders, contacts those lenders, and passes information back and forth between the borrower and their lender. The loan broker doesn't do any of the other work to get to that point. They don't identify and select properties for acquisition. They don't bring the business to the point where potential capital sources or lenders might be interested in that business. They don't develop detailed business plans. They don't negotiate contracts. They don't draft the documents necessary to provide the lenders. Though that all happens, the owner of the business does that before engaging a loan broker. And those are the services that Mr. Cohen provided. Those are his real estate advisory services. He also separately provided loan brokering services, and those were compensated with a commission fee. But the real estate advisory services, that 20% interest, was for something different. And that's quite clear because that 20% interest was worth $4 million in 2017. Weber can't explain why he would offer Mr. Cohen an interest worth $4 million for loan brokering services he could go out and get someone else to do for less than a 20th of that amount. And his loan brokering theory also doesn't add up because after Mr. Cohen was already paid that commission, the parties continued to document that 20% interest, which shows that it was for services other than the loan brokering services.
Can I ask about the back and forth, the email traffic that you say really doesn't affect the legitimacy or the validity of an oral agreement? But one of the, and there was more than one, I think, but one of the emails that got my attention was one from Mr. Weber in September of 2017, where he states that he has to know by the weekend whether or not you would become a partner. I mean, unless he somehow predicted that this would end up here someday, that seems like a pretty contemporaneous assertion that there really isn't an agreement, that the parties are still trying to figure out exactly what the terms of the agreement are and putting the onus on your client to tell him whether or not he wants to be a part of this deal.
Well, Mr. Weber could make that argument to the jury, but that doesn't blatantly contradict Cohen's testimony because there are other inferences the jury could draw from that email. One is that email was sent to both Mr. Cohen and Mike Michaels. A jury could conclude that Weber's uncertainty was directed to Mike Michaels, who actually ultimately didn't become a partner. And that's a reasonable inference because Weber can't reasonably claim he wasn't sure whether Cohen wanted to be a partner. Cohen had already worked 8 years based on the understanding that he was going to be compensated with a % interest.
Well, not you, but did your client then respond, you can't reasonably claim that I'm not a partner in response to that email?
No, the point of that email was to transmit the first draft of the written
No,
document.
what I'm saying is when your client got that email, maybe if in fact he really thought that there was an agreement, wouldn't he have said, by the way, we have an agreement, we're just dotting the i's and crossing the t's here?
Well, after he got that email with the draft, he called up Weber. They had a phone conversation. In that conversation, Mr. Cohen said, these extra terms that you're adding are not consistent with our agreement. These are unacceptable, so I'm not going to sign it. So he didn't respond in writing to that email. They had an oral conversation. And I'd point the court also to the emails that Mr. Cohen sent to potential lenders during that time, after the parties had reached their April 2017 oral agreement. He said consistently in his emails, I'm going to have a 20% interest in this business. From that evidence alone, the jury could infer that they had in fact reached an agreement that Mr. Cohen would have a 20% interest. So this case comes down to competing testimony about what happened in oral conversations and competing inferences that can be drawn from written documents. Those written documents.
Is there anything in the record that says those conversations over the phone, any of that was memorialized?
I'm not sure what you mean by memorialized.
In writing regarding you said they had these conversations over the phone. I mean, is there any reference anywhere in writing?
Yes, in May 2022, Mr. Cohen sent an email, which is at JA 729, which he says to Weber, "I'd like to complete documentation of our agreement. That is, finish taking our existing agreement and reducing it to written form." And he says to Weber, "You've stated over the years that we don't need to rush to sign this agreement because you've been acting consistent with your promise, because you've been, because you honor your oral promises, and because we have an agreement." That's in writing. Also, some of the written exchanges, for example, in 2018, refer to, pursuant to our conversation last Tuesday. Those written documents refer to the oral conversations that the parties had. The jury has to be allowed to decide whether the written exchanges were simply written exchanges because the parties didn't have any oral agreement, or whether those were attempts to reduce the parties' existing oral contract to a formal writing.
Thank you, Mr. Doble.
Thank you.
Mr. Killian?
Good morning, Your Honors. May it please the Court. Brian Killian for the appellees. The District Court got this one right. There's no genuine dispute as to the material facts that Cohen would need to prove his claims to recover 20% of the profits that Weber's business has earned over the years. These two highly sophisticated businessmen, along with their lawyers, spent a lot of time negotiating over various ways in which Cohen could acquire the interest that he wanted. But ultimately, they never mutually, objectively, and simultaneously agreed to all the necessary terms to complete that agreement. Under California law, a court can render judgment as a matter of law on the non-existence of a contract based on the objective, contemporaneous written records. And as the court has already explored, the parties had a number of back and forth emails exchanging drafts in the end of 2017. Every one of those drafts had different consideration for the parties to provide. And even when the parties were talking about profit, they were not talking about profit defined in the same way. They defined in those contracts a cash distribution interest or a net cash interest, which they each were characterizing as profit in a different way of calculating it. And none of those contracts was ever signed. Moreover, as the court noted, there are none of the telltale signs that the parties reached an oral agreement. No one said, "We've already reached an oral agreement, let's just write this down," or no one said, "That draft you sent me doesn't look like what we talked about." And in fact,
Well,
to
that's
Judge
not an absolute requirement under the law, right? But you're just saying that's further indicia of the fact that the parties never agreed.
Correct. And I think the more important point, though, Judge Diaz, along these lines, is that the parties individually expressed their understanding that the other side had not yet agreed. Judge Diaz, you mentioned the email that my client sent to Mr. Cohen in September. It's at page 401 of the joint appendix, where he wrote and said, "It's not clear what your position is. Do you want to move forward?" And I respectfully have to disagree with my adversary's characterization of that email as potentially being an email only to Mr. Michael. It says, "Gentlemen, I received this draft. I must know whether you desire to move forward." He's referring to both of them simultaneously, not to just one of the two. Similarly, Mr. Cohen's lawyer wrote an email that said the parties were working, quote, "on several key issues." This is at JA 534. In other words, representatives from both sides in the midst of this back and forth expressed to each other at that time that their own side did not perceive that the other side had reached an agreement. They both reflected that this was still an open arrangement. And I think
I understand an argument that counsel made this morning. He contends that California law prohibits, I may have misunderstood him, but that California law prohibits a court from taking into consideration on the question of whether there's an oral contract, the fact that the oral contract was never mentioned in later written documents. Is that an accurate statement?
I believe my friend on the other side is overstating the Senate California law on that. In cases like Patel and the CSAA case on which they rely, both sides had admitted and agreed that there was an original contract between them. But what happened subsequently is that when they were trying to write it down, as he said, someone was inserting provisions that both sides had recognized was not a part of the original agreement. And as the Court of Appeals said in the CSAA case, when that happens, you don't have to sign the subsequent contract. It doesn't diminish the existence of the earlier contract. But the key fact in those cases was that the existence of the original agreement was undisputed by the parties. Here, however, there is no original agreement. And so the question whether the parties were able to write it down is a material fact to deciding whether that existed for two reasons.
When you say that, are you saying that the agreement as it exists, even taking it in the light most favorable to Mr. Cohen, the oral agreement just doesn't add up to a contract? Is that your argument?
There's a couple aspects to that, Judge Diaz, yes. One is that the material terms, all, and it may be specific, necessary terms, because what Mr. Cohen was going to give, what Mr. Weber was going to give, that's the consideration. If those are not resolved, there cannot be a contract. A court cannot just fill that in later on. That is the essence of the agreement. So it's more than a material term. It's a necessary term. And that was never resolved by the parties objectively, mutually, and simultaneously during the course of that process. So it's more than just his recollection is incomplete or wrong, or that he doesn't have enough evidence, to be specific. It's that he doesn't have enough evidence of the material terms that is necessary to create the type of contract that he claims it was created by the parties. The court explored with Mr. Cohen's counsel the issue of consideration. California law is clear that where someone just offers a gift for prior services, that's not a contract. And so in the court below, it was very important to Mr. Cohen's theory of the case that not only was this alleged agreement for the prior 8 years of work, but also for the closing of the Herndon loan. And then when it came time to close the Herndon loan, and when it did close, Mr. Cohen didn't say, where's my equity, where's my profit? He issued an invoice for $150,000, which is the same commission that he was entitled to under the very long-standing commission-based arrangement that the parties had. That's key, because it shows that Mr. Cohen himself also recognized that there was no change in his status vis-a-vis Mr. Weber. Instead, he collected the commission for that work that he would have been entitled to had the parties never reached an agreement.
The other component of that consideration was the years that he had spent working on this project up until the date of the alleged oral agreement. And he says that even though past consideration in the abstract might not be sufficient, if you give up a claim in quantum merit in expectation of a contract, that's good enough. Is that what California law says?
Not in our view, Your Honor. None of the cases say that you have to be giving up more than a legal right, and quantum merit is not a legal right. There's no evidence that this was a settlement between the parties over a claim for quantum merit. Quantum merit is when court inequity, where a person doesn't have a legal right, says, but out of fairness, you deserve a little something. And so we don't think that he was settling a 9-year running quantum merit claim in early 2017 when he alleged that he was getting a profit or equity interest at that time.
Of course, he makes a claim here now for quantum merit. Right?
Sure, he does make a quantum merit claim in this case. This is part of the reason why reaching all the way back to the beginning of time doesn't work under quantum merit. But the law in California actually is on quantum merit is very clear that a party cannot obtain profit or equity through quantum merit. This is in the Maglica versus Maglica case that we cite in our briefs. The court says that sort of interest in a business is, quote, always the result of specific bargaining. Quantum merit is about giving someone the reasonable value of the services that they provide. And giving an equity or profit interest in someone else's business is not the reasonable value of the services provided. That has to be done by contract in California law.
Even though quantum merit is an equitable remedy, wouldn't the argument over whether do profits or equity interest or do some hourly compensation for other services I rendered, isn't that in effect even though it's in equity, a damages question? It doesn't go to the existence of whether or not the elements of quantum merit have been proven. No,
because I believe, Your Honor, that In this case, he is seeking very clearly the 20% profit interest. This is not a quantum Merowit claim where he's asking for the hourly rate for phone calls that he made in the 2-year period before the start of this case. The ad damnum in his complaint and the arguments that he has made for every one of the causes of action is for a 20% profit interest. So for the breach of contract, promissory estoppel, and quantum Merowit, that's the relief he seeks. And so in our view, this is more than just a measure of damages issue. The question is the specific relief that he's seeking in this case. Can he get it through quantum Merowit? And the answer is no. As a matter of law, he cannot. So it's not just a quantification question. We think it goes to the heart of the case that he brought
So
here.
would another way to say that from your standpoint be that if there is a quantum Merowit claim, that he has pled himself out of a recovery because the method of compensation is prohibited?
Yes, that's our view as to that. Now, the district court also said that as to quantum Merowit, in the 2-year period before the filing of the case, technically with a little bit longer because the parties had a tolling agreement, so we'll call it within the limitations period, Mr. Cohen had engaged in only 6 specific acts on behalf of the Weber businesses.
But he cites this John Stone case.
We cite the Johnston case,
John
actually,
Stone
yeah.
case and says that it regarding, I guess, the last service and then incorporating all of this other. It was I guess a group of services.
Yeah, Johnstone case was actually very similar to this one, where 2 men went into business with each other to create medical devices, and one was not given compensation for it. And then near the very end of that, at the end, he filed a quantum Merowit claim asking for something. And the court, in the California court, looked back only during the limitations period and said you provided some discrete services in that time period to be sure, but those services were not dependent upon or contingent upon the sort of work that you had done in connection with this business in the past. They were discrete services. So those discrete services did not provide a continuation that would allow sort of this, an understanding that there was just one service provided over a 5 or 7 year period. The court said you only can get recovery for the discrete services provided within the limitations period. And that's what happened here. He provided 6 discrete services in response to our interrogatory request, asking what did you do under this alleged real estate advisory service. He provided 6 within the limitation period, and then at his deposition, and this is at page 196 to 198 of the joint appendix, he admitted that each of those services was in connection with a loan. He was paid for 3 of those 6 services under the loan, the commission-based loan brokering agreement that the parties had always had. And the other 3, he wasn't paid because he didn't close a loan. In other words, those were not truly real estate advisory services. They were loan brokering services. So the only work he did within the limitations period was not the kind of work that he would wish would connect back all the way to 2009 to this period of real estate advisory services. And that's the ground on which the district court found that the quantum Merowit claim lacked and rendered judgment as a matter of law.
So you're saying there was no unjust enrichment, I guess, on the part of
Correct.
your-
The services that Mr. Cohen provided in the limitations period were either compensated pursuant to the commission agreement, or they weren't pursuant to the commission agreement because no loan was closed. So he got the benefit of his bargain for those services as well.
As I understand Mr. Doble's bottom line argument here is that because we're dealing with an oral contract, inevitably what this is all about is a battle of credibility between two individuals. One who says, I had an oral contract, here are the terms. Another who says, no, we didn't agree on that. And I suppose, I guess your argument is twofold. First, even if you assume in the terms that Mr. Cohen has suggested, they're legally insufficient. But if we
Correct.
disagree with that and think that they are, then this is a jury question, right?
No, I think there's 2 other responses to that, Judge Diaz. One is, independent of whether the parties sufficiently reached all agreement on all the necessary and material terms, which is our primary argument, right? That consideration was never really finalized. The type of profit and the measure of profit was never actually finalized by the parties. Putting that aside, the parties also separately objectively manifested their desire that they would not be bound unless there was a writing. And under California law, where the parties objectively manifest through their actions or words that they will not be bound until there's a writing, then there's no contract. This is the Lewis Lesser case that we cite in our briefs. And here the parties objectively manifested that because they were swapping drafts back and forth, because they hired lawyers to do so. And maybe the capstone on this is that each of them, the individuals in this case, testified at JA 194 and JA 386 that they went through this whole process because they wanted a writing to memorialize their contract. They were not going to be bound without that. So even if they reached a meeting of the minds orally as to all necessary terms, and we don't think the evidence shows that, but even if they did, they also wanted to have a writing, and because they were unable to get that writing, there was no contract. So for that reason as well, this is not a jury question. The objective evidence, which again is what California law and the Bustamante case says, is enough for a court to render judgment as a matter of law, shows that there was no mutual, simultaneous, objective meeting of the minds to all necessary.
And when you say that, that the parties intended to be bound, did not intend to be bound unless there was a writing, there's no express statement of that fact, right? You have to sort of infer that from the exchange written and oral. Is that your point?
Yes, in the Lewis Lesser case, the court did say that the parties can manifest that without verbal words. They can manifest the intent to be bound through their actions, and that's the only inference that can be drawn from all the effort that the parties went through here on breach of contract. So just to be clear, we argue that the contract is incomplete. There's no evidence of all the necessary terms, that the parties, as a matter of law, wanted a writing, and they didn't get that writing, so there's no contract. And then we have the argument about consideration, that the prior work is not sufficient consideration, and that the future work, closing of the Herndon loan, Mr. Cohen billed $150,000 for that, which he only did because the parties never actually had changed their relationship. They had never had the contract that would have gotten him 20% profit or 20% equity when he closed the loan. He closed the loan, issued the invoice because nothing truly had changed. And for that reason as well, it's evident that there was no consideration actually exchanged vis-a-vis that contract. Unless the court has any further questions, we ask that the district court's decision be fully affirmed.
Thank you, Mr. Killian.
Thank you.
Mr. Doble?
The Lewis Lesser case that counsel relies on itself says, and I'm quoting, preliminary negotiations ordinarily result in a binding contract when all of the terms are definitely understood, even though the parties intend to later execute a formal writing. And in Lewis Lesser, the objective manifestation of intent not to be bound were express statements by the plaintiffs before the letters were signed, telling the defendants that they weren't binding until they signed a formal writing. Judge Diaz, as you point out, there's no such express statement in this case. Counsel relies purely on the subsequent exchange of written drafts. But that's entirely consistent with what Cohen says happened here, which is that the parties reached an initial agreement on oral terms and then attempted to negotiate a formal writing. And when parties don't finalize the terms of that formal writing, that's fine. The oral agreement still remains binding. And that oral agreement was complete on its own terms. With respect to the quantum merit claim, we're not trying to obtain an equity or a profit. We're seeking damages for the reasonable value of the services. And what California law says, including the Maglica case that counsel relies on, and also the Cazares and Watson case, which we cite in our brief, is that the best evidence of the reasonable value of the services is that the value that the parties put on those services. Here, that value is a 20% interest. So we're not asking the court to order Weber to give Cohen a 20% interest of his company. We're asking the court to order Weber to give Cohen the value of a 20% interest.
What about the statute of limitations issue that you have?
Yeah.
In response to his position that there's no, I guess, unjust enrichment because of the six interactions that would have occurred within the statute. 3 of them, I think he's saying, were paid through brokerage fees, and the other 3 didn't close.
Yeah, so I want to make a couple points on this. And first, I'd like to make a point that I think was in the briefing but didn't come out as strongly as it could have. A quantum merit claim doesn't accrue until the payment is wrongfully withheld. Here, payment wasn't wrongfully withheld until May 2022, when Weber told Cohen for the first time, I'm not going to give you this 20% interest. So regardless of the fight over what services counted as loan brokering and what counted as real estate advisory services, under California law, the quantum merit claim didn't accrue until 2022. Now, with respect to the services, that's an additional reason that the quantum merit claim didn't accrue until that point. The statute of limitations doesn't begin to run until the last services are rendered, as Your Honor pointed out. Here, counsel ignores Cohen's testimony that in addition to the specific services he listed in that interrogatory response, he also, in that same interrogatory response and in his deposition, said that he was available for Weber 24 hours a day, 7 days a week, and that he spent hundreds of hours on the phone with Weber providing these advisory services. And he testifies that he was rendering those services right up until May 2022, when Weber suddenly repudiated. With respect to those specific listed services, those services were not loan brokering services. They were real estate advisory services. And Cohen's testimony on what counts as real estate advisory services and what counts as loan brokering is undisputed for the purposes of this summary judgment motion. And I'd just like to give one example of those specific listed services. June 2021, discuss and advise on potential acquisition of property in Aurora, Colorado. A loan broker does not advise clients on which properties they should acquire. That's something that's an advisory services that Mr. Cohen provided as part of his separate expertise. So even if you just look at the specific listed services, Mr. Cohen provided advisory services after April 25th, 2021. The bottom line here is that Mr. Cohen provided 13 years of advisory services that brought Weber's business from below $0 to $115 million. And he hasn't been compensated 1 cent for those services. So for those reasons, we ask this court to allow Mr. Cohen to have his day in court and to attempt to prove to the jury that he should be compensated for those services.
Thank you, Mr. Doble.
Thank you.
Thank you both for your fine arguments. We're going to come down and greet counsel, take a very short recess, and then come back for our third case.
This honorable court will take a brief recess. Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
Be seated, please.
Our third and final case this morning is 23-6890, 23-6950, Moreno versus Folsom. Mr. Whalen?
Good morning, Your Honors. May it please the Court, my name is James Whalen. My colleagues Sam Irvin IV and Colin Saint here on behalf of Mr. Moreno. The trial court erred in this case in two ways. First, it applied state law to limit the testimony of Mr. Moreno's expert witness, Dr. Bilbrow. Federal law, not state law, governs the admissibility of expert testimony in federal court. The trial court's application of state law was error. Second, compounding on that error, the trial court took the case from the jury and held that the evidence that it did admit was insufficient to support Mr. Moreno's claims of deliberate indifference and medical negligence. That again was error. The trial court should have sent the case to the jury because there was sufficient evidence below to create jury questions on both of Mr. Moreno's claims. The evidence below showed that Mr. Moreno narrowly escaped death and survived with lasting injuries because for 3 days, the H1N1 swine flu was allowed to slowly suffocate him, smothering his lungs and preventing them from absorbing the oxygen necessary to feed his brain. His condition was allowed to deteriorate so dramatically because his only treating physician, Dr. Carol Balsham, did not provide any monitoring instructions in her treatment plan to the nursing staff. That simple but critical omission meant that from Friday to Monday, no one listened to his lungs, no one counted his breathing, no one measured his blood oxygen content. And as a consequence, he nearly died.
I'm fairly sure the panel's familiar with the factual background here, but among other issues, this case raises a very interesting, almost law review, bar exam type question on the application of procedural and substantive provisions. So why don't we go directly to why you say the district court erred in applying the North Carolina rule?
Yes, Your Honor. So under Shady Grove, there's a two-step analysis. And the first step, and this court's decision, recent decision in Pledger, outlines these steps very well. In the first step, we do not look at state law. We look at federal law to see if there's a federal procedural rule on point. And if there is, and it applies and it answers the question in dispute, then the only remaining questions are whether that law is constitutional and consistent with the Rules Enabling Act. And here there is a federal rule on point. Federal Rule 702 governs the admission of expert testimony in federal court. It uses the same language that was in Civil Rule 23 regarding class actions that the Supreme Court addressed in Shady Grove. It uses the word may, meaning that...
Well, we have to look at the substance of what a party is required to prove in order to prove the elements of its cause of action. And this is where I think the case is a little confusing and isn't quite the same as Shady Grove or Pledger. Pledger, for instance, you had a certificate requirement, but it didn't affect the proof of the elements of the cause of action. And the same thing in Shady Grove. In Justice Ginsburg's dissenting words said it limited the remedy, but it didn't affect the proof of the elements of the cause of action. Here this seems a little bit different. It's not a filing fee. It's not a certificate that's not admissible at trial. It's not an element of the damages you can recover. But it seems to take on some substantive characteristics in that you can't prove the elements of the cause of action for medical malpractice unless you have qualified expert testimony, except in very rare circumstances. So that seems to introduce an element here that's not present in Pledger or Shady Grove.
Your Honor, I think I'd slightly disagree. Well, I would agree that we have to look at state substantive law to find the elements of Mr. Moreno's second claim, the medical negligence claim. But there is nothing in the state statute governing that requires expert testimony at all, let alone expert testimony that meets certain procedural thresholds. There is case law in North Carolina that says, generally speaking, to prove medical negligence, you need to have expert testimony. But we have expert testimony here. The question is whether this separate rule, which is contained in the state rules of evidence, places a hurdle that we must observe in federal court.
So is it your bottom line view that the North Carolina requirement, which, and you're right, it's not in the statute, it's in a rule unlike the Virginia case, that is purely a procedural rule and there's no substantive part to it?
So, Your Honor, I'd take two steps. I'd first, to avoid your question briefly and then to answer it. And the first step, I'd say the question before the court is whether Dr. Bilbrow's testimony was properly excluded. That is a question that is answered by federal Rule 702. And so the court does not even need to reach the question about substance versus procedure to answer that question. We can talk about the sufficiency of the evidence to support the second claim, but on the procedural question of whether or not Dr. Bilbrow's testimony should have been admitted, that question is answered by Rule 702. If the court were to reach the second step and say, now let's look, as the court did in Creekmore, at whether the Rule 702 is procedural or substantive, then yes, Your Honor, I would argue that Rule 702 is quite clearly a procedural, not substantive rule.
So your argument, I take it, is if it's a procedural rule, even if it is in reality substantive, that's all you need to look at.
So in the first step, looking at the federal rule, we look at whether there's a federal procedural rule on point, and then we
I
look
think we
at
all understand the issues, and when you look at Pledger and Shady Grove, you can see how these apply, but as my earlier questions indicated, it seems like to me this is a little bit different. Not to say that you're not correct, but that this involves a different element than was involved in those two cases.
So on the question of whether Rule 702 is procedural or substantive, there are a couple of additional points that might clarify that for the court. For example, Rule 702, the state Rule 702 is contained in the rules of evidence, which by their own terms only apply in state court. That's contained in Rule 101 and 1101 of the North Carolina Rules of Evidence. So if the North Carolina legislature was attempting to create a substantive rule that was going to apply beyond North Carolina courts, it could have done so, and it didn't. And that's in stark contrast to the Virginia statute, which by its own terms did apply to any claim for medical negligence that arose in Virginia. So that is another distinguishing factor here. And I should say that the parties are in agreement that North Carolina law and Virginia law are materially different and should be applied differently.
So can I follow up on Judge Agee's questions? Because this is a little bit murky. We've got the Creekmore decision, which I want you to opine upon here in a second, but let me give you an extreme example. If Congress had, in some way, shape, or form, inserted a rule that said if a doctor is sued in federal court, strict liability applies, right? There's no test of negligence. That's a rule that would seem to supplant the state rule, but clearly I think that rule would not be enforceable because it affects the elements of the cause of action, I don't think. Do you agree with that?
Your Honor, it would, so that under the first step analysis in Shady Grove, there would be a federal rule on point. So the next question would be, is that rule consistent with the Rules Enabling Act?
Right.
Sounds to me in the hypothetical that the answer would be no.
Right. That's what I think. But at least at first blush, this rule is a little bit different because it doesn't really affect, well, there may be a disagreement as to whether it affects the cause of action, but it principally affects the manner in which the litigant can prove the elements of the offense. In North Carolina, if you're in state court, you've got to get a doctor that satisfies the requirements of an expert for that particular cause of action, whereas in federal court, all you need to do is satisfy Daubert and the federal rule. Now, admittedly, that results sometimes in different, there may be different results as in federal court and state court because of that. But that's essentially what Shady Grove predicted and suggested that there was nothing wrong with that. If Congress has spoken on a matter that has nothing to do with that is in a manner that is not inconsistent or beyond the scope of Congress's ability to act, then that's the end of the story. And I guess from your position, this is exactly that kind of rule that Congress has indicated, that at least when it comes to experts in federal court, there is no distinction between the causes of action. The rule applies consistently across the board, and it's either a fortunate or an unfortunate accident if you happen to land in federal court or state court, but that's the way the rules apply.
That's correct, Your Honor. And the analysis that Pledger walked through is to look at the federal rule and see, does the state rule conflict with that? Does the state rule do something different? And here, there's no question. The federal rule is categorical, uses the same language that's used in Rule 23, addressed in Shady Grove. It's a categorical rule of permission that allows a witness who meets the qualifications of Rule 702, Federal Rule 702, to offer expert testimony. That those qualifications are disjunctive. You can have education or training or experience. That contradicts the state rule, which requires specific training, specific experience, specific recent experience. And so because there's a federal rule on point, it applies categorically. It does apply to this case. It answers the question in dispute. The only other question for this court is whether or not Federal Rule 702 is consistent with the Rules Enabling Act and is constitutional. There's been no argument anywhere in this case or anywhere in the country, to my knowledge, in the cases that I've read, that Rule 702 is unconstitutional or beyond the rule.
So how do you reconcile our Creekmore decision?
Your Honor, Creekmore skipped the first step of Shady Grove, so to the extent that this court looks at the first step of Shady Grove, in this case, Creekmore does not inform the court's decision. To the extent that the court reaches the second question, after looking at the federal statute, decides to look at North Carolina law to see if it is procedural or substantive, applying Creekmore would get you a different result in this case. And I've addressed a couple of the reasons. One is that by its own terms, North Carolina law only applies in state courts, whereas the Virginia statute applies in whatever case arises in Virginia. The Virginia statute at issue was the standard of care statute. The statute set out the standard of care and then continued and said, in order to meet the standard of care, you need an expert, and this is what the expert has to be able to, the qualifications of the expert. So structurally, the legislature was trying to say that this is a substantive rule. North Carolina has done that very differently. The equivalent state law in North Carolina does not have any of those requirements. It's a separate rule.
But in the first instance, you would say that the Creekmore decision just doesn't account for Shady Grove for the first step.
That's right, Your Honor. It does not cite Shady Grove. It does not follow the Shady Grove analysis, and so Shady Grove is controlling. And we'd ask the court to just follow Shady Grove as the court did in Pledger. And I'll note, just to tie back to Pledger a little bit, Pledger dealt with, it was a West Virginia rule, but it was a very similar thing. It's the credentialing statute, Rule 9J, which has come up in this case in the cross appeal, is the partner rule. So in North Carolina, there's Rule of Civil Procedure 9J, which is about having the same medical negligence expert opine in the first instance that the cause of action should proceed. It was adopted in the same session law as Rule 702B. It was adopted for the same purpose. And Your Honor, my time has expired.
Thank you very much, Mr. Whalen. Ms. Wood?
May it please the court. My name is Maria Wood, and I am here on behalf of Dr. Carol Bolsham, who was originally one of almost 20 defendants in this case that was filed more than 4 years ago. Notwithstanding that there was not an expert critical of Dr. Bolsham prior to the filing of the lawsuit, at any point during the pendency of the lawsuit, or at trial, the case continued on to trial. And at trial, the third time was the charm, and the district court correctly and properly granted our motion for Dr. Bolsham's motion for judgment as a matter of law.
why don't we go kind of to the $64 question here now, and that's, why doesn't Shady Grove require that we vacate here? Because there's, as the opposing counsel argues, there's a federal procedural rule that would seem to apply here. Why isn't this just a step one Shady Grove examination?
Yes, Your Honor. In this case, actually, North Carolina Rule of Evidence 702 is very different than the federal rule. It requires and imposes heightened requirements for an expert witness to qualify as an expert at trial. And because of those requirements, under North Carolina Rule 702, it is inextricably intertwined with the elements and the statutory requirements that need to be shown in order to prevail on a claim of negligence, which is defined under North Carolina General Statute 90-21.12.
Well, the same was, I'm sorry, go ahead. The same was true in Shady Grove in a different context. It was a class action dispute with two different requirements for certifying a class action, one arising under New York, one under the federal rules. And you could make the same argument that that requirement in New York was inextricably intertwined with the ability of a plaintiff to bring a class action. And the Supreme Court had no trouble suggesting that if the rule simply affects the manner in which the plaintiff is able to bring the claim or present the evidence, but doesn't affect the cause, the elements of the claim, in this case, in your case, negligence, that's not substantive, it's procedural.
In this case, though, Your Honor, it does affect the elements of the claim.
Well, the elements of the claim are still, it's a negligence claim. That hasn't changed. The only thing that changes is who can testify as to the standard of care. That strikes me as not affecting the elements, just the manner in which evidence is presented.
I would argue that it is necessarily, they're tied to, it being tied to who can testify as to the elements of the claim. In this case, when there is only one expert who testifies that he's not critical of this particular defendant, it does not, it's a different scenario in this case, as in Shady Grove. This case is much more aligned with the Creekmore case, which was also.
Well, I agree with you, but the question is whether or not Creekmore survives in light of Shady Grove. If Creekmore applies, then you win, I think. But if we have to apply Shady Grove, and the last time I checked, we still are the inferior court here, and Shady Grove is a Supreme Court decision. We have to wrestle with that. You have to wrestle with that. So you need to tell us why Shady Grove doesn't apply in this case.
Shady Grove was a very different scenario. And in that situation, as Your Honor stated, it was a class action. And I continue to maintain that it does. In this case, the situation is that it does squarely affect the elements of what the plaintiff has to prove.
Well, explain to me how it does.
Yes, Your Honor.
Go ahead.
90-21.12 lays out the requirements of a medical malpractice claim. And the first requirement is that there needs to be expert testimony in order to show and establish that the defendant provider violated the standard of care. And that expert also has to establish what the standard of care is. The way that the case
key
law,
factor, though,
much of
it
which.
seems like to me is that in Shady Grove, Pledger, and in this case, the claim to prove the duty of care, the standard of care, what one has to prove has not changed depending on who the witness is. So in Shady Grove, for instance, it's a class action case, And the limitation there from the state court was not on what is the element of the class of action. It was, what's the degree of recovery? And here, it would seem like that whether or not it's the requirement of the physician expert or a federal rule on a Daubert expert, that the elements of what have to be proven has not changed.
Yes, Your Honor. The elements, we've already discussed the elements. But it still goes back to how Rule 702 has been applied, and in interpreting Rule 702 in North Carolina, it has been applied in a substantive manner, similar to the analysis in Rule 9J.
Right. Well, that's, Justice Ginsburg would agree with you, and so would Judge Quattlebaum and Pledger, but they were on the short side.
I understand, and I do though
I'm not
think.
saying that either one of those was wrong, but they're still on the short side.
And with respect to the dissent by Judge Quattlebaum, it was the dissent, but I do think he made some comments which are instructive here, and he noted. And it was his opinion, he discussed in Pledger that a pre-suit certificate of merit, which was the issue in the Pledger case, which imposed a 30-day requirement, was not addressed, is something that's not addressed in laying out what is required in a pleading. That type of rule is something that is procedural. It's, you have to have this requirement 30 days ahead of time. And that situation in Pledger is different than what we have here. And just to give an example as to how that compares to Rule 9J, which is the pre-filing expert certification requirement in North Carolina, Rule 9J is not this a pre-suit service of a certificate of merit like we had in the Pledger case. Rule 9J, it's a mandatory requirement, and it can be, it is become a substantive rule in that it affects the merits of the claim, because if it is shown through discovery and through depositions that a plaintiff has not complied with Rule 9J and does not have an expert who is qualified, that goes straight to the merits, and that's a substantive issue. So Pledger was a very different situation than we even have in this case.
And Creekmore, in looking at the Virginia rule, it seems to be substantive, whereas here, the North Carolina rule seems to be somewhat as a I guess a gatekeeping as to who the expert, what the years of practice as to the expert. It actually seems a little more procedural than substantive. I'm curious to hear your response regarding the difference between the Virginia rule and the North Carolina
Sure.
rule.
Yes, Your Honor.
And also, because it seems as if the Virginia rule gets into the substance, it's about substance, it's about qualifications. Here, if we even look at the legislative intent, it's about procedurally reducing the number of frivolous lawsuits, medical malpractice suits, which seems to be procedural.
Actually, Your Honor, I would argue that it is more of a substantive rule, and I will explain why. Rule 702B of the North Carolina Rules of Evidence requires that, as we've discussed, during the year immediately preceding the date of the occurrence that is the basis for the action, the expert witness must have devoted a majority of his or her professional time to A, the active clinical practice of the same health profession. Now, how that is defined, how professional time is defined, and how active clinical practice is defined has been the subject of multiple, probably dozens of court decisions in terms of trying to define this rule, and it has been applied substantively. We've cited several of those decisions in our briefing, including Moore versus Proper. And in that case, it was addressing the issue of what is clinical, what does an expert have to do in order to qualify as having had the requisite amount of clinical time. And the courts have concluded in North Carolina that that has to be hands-on, the active practice, treating patients, not administrative time. So,
But if we were in a Shady Grove world, which we are for better or worse, that would seem like to be a step 2 question, not a step 1 question. So it seems like to me that, after decades of trying to separate procedural and substantive items, after Erie Railroad, the Supreme Court reached the position in Shady Grove that just said, this is a constant morass. We're just going to have a clear rule for better or worse. And so here's the clear rule.
the Supreme Court did make that determination in the Shady Grove case, but there are a lot more issues and factors involved in this particular situation involving the testimony of this expert. In this case, even if the expert had been allowed to testify, he was not critical of our physician. When we had deposed him initially in the case, he was critical of other providers, but he was not critical of our physician. So to the extent there was any error in applying North Carolina Rule 702, that it was a harmless error. Even if we were to apply Shady Grove.
Do you have anything else, Ms. Wood?
I would just, in conclusion, Your Honor, yes, if I may, in conclusion, I would just, again, request that this court affirm the granting of the judgment as a matter of law. As I mentioned a minute ago, it's not just a situation of whether or not Dr. Bilbrow, of Dr. Bilbrow and whether his qualifications should have been addressed by federal or state rule. Even if he had been admitted to allowed to testify, he would not have criticized Dr. Bolsham. There are many other elements of the claim which we've not gone into detail, but there are other elements of the negligence claim which the plaintiff at trial still failed to present evidence as to. And in addition, with respect to our cross appeal, one of our bases, Rule 9J, we again would submit that the Pledger case does not apply here. And in this situation, Rule 9J, as there's no federal counterpart with the pre-filing certification requirement, we would request that the denials of our 12B6 motions and our summary judge motions be reversed. Thank you.
Thank you, Ms. Wood. Mr. Whalen?
Your Honors, if I may, I'll pick up close to where opposing counsel left off, and that's with the harmfulness of the error. I think we've discussed that Dr. Bilbrow's testimony should have come in under the federal rules, and it absolutely was harmful to keep it out, both to his state law claim and to his federal law claim, which is one of the reasons why Shady Grove, I think, cuts this clear line, is in a case like this where we have a federal claim and a state claim, it becomes that much more complicated.
If it were to go back, your expert, if that's the same expert you're going to use, is still going to have to meet Daubert-related qualifications in order to be permitted to testify.
Correct, Your Honor. It's not a free pass. He still has to meet those qualifications. We've argued in the brief both because the issue's been waived and because even if it hadn't been, substantively, he will meet those qualifications. We feel confident either if this court were to just reverse or to vacate that decision on the expert testimony, we'll be able to get his testimony admitted. And if it had been admitted, it absolutely would have affected the outcome. The trial court specifically pointed to a lack of expert testimony in adjudicating both the deliberate indifference claim and the medical negligence claim. Looking at the deliberate indifference claim, the court specifically said that the lack of expert testimony, that the care provided by Dr. Balsham was so grossly incompetent that any reasonable juror could find that it rose to the level of deliberate indifference. That's at JA 520 and 521. And the judge also pointed to the causation issue, arguing that there was not sufficient causation evidence, something that Dr. Bilbrow specifically tried to testify about, but was excluded. And especially when we're talking about deliberate indifference, there's no question that the federal rule should have applied. And Dr. Bilbrow's testimony relating to the deliberate indifference and causation absolutely should have come in. He also should have been permitted to testify, as he did on voir dire, that the lack of instruction was a breach of the standard of care. He specifically testified to that. We've gone back and forth in the briefing on that issue, but the quote is explicit that while he did not object to the specific things that happened that he was asked about in that question, he did object to the lack of instruction, and it was the lack of instruction that caused his injuries. There's testimony from Dr. Bilbrow that nurses would not have tested, or would not have checked, would not have monitored Mr. Moreno, but for instruction, that the quarantine procedure did not include any such instruction. The only place that this instruction could have come from was Dr. Balsham. Dr. Balsham failed to produce that instruction. And so that evidence is sufficient to show the medical negligence side and the fact that Dr. Balsham knew that he was suffering from flu-like symptoms and that quarantined him along with other confirmed cases of the flu, showed that she did subjectively know that he had a serious medical condition and was at a substantial risk of serious harm if his condition was not properly monitored. She knew that providing that monitoring instruction
We wouldn't
would
get
work.
into any of this, would we? I mean, if we send it back because there's a Shady Grove violation in the first instance, why would we look at any of this stuff?
The court does not need to I only raise it because opposing counsel has raised harmlessness of the error, and we think we're quite confident that the error was not harmless, that there was substantial evidence, as we've argued, substantial evidence beforehand, but certainly with Dr. Bilbrow's testimony to get this case to the jury. And so
Can I
this
ask you
court-
about the cross appeal, which is a little, is part of this case? And your colleague on the other side would have us go back to the very beginning and look at the pleadings and decide that if they were defective from the get-go, that in itself is sufficient to affirm the district court decision. That seems a little odd, but on the other hand, I mean, we have a Rule 12b-6 for a reason, right? So what's wrong with that?
Dupree is what's wrong with that, Your Honor. The Supreme Court held in Dupree that we don't go back to the beginning. We don't discuss factual disputes that go back. The opposing counsel can raise all these same arguments just in the context of what evidence came in at trial, which we have debated in the lead appeal. And so all of the debate on the substantiality of the evidence in the cross appeal is not properly before the court.
Is there a distinction between factual and legal issues when it comes to going, even considering whether or not to go back?
Yes, Your Honor. Purely legal issues that it would be a waste of time to try to raise again because they are categorically resolved no matter what the facts could be. Those purely legal issues can be raised again. On my read of the cross appeal, the only one that could fall in that category is the Rule 9J motion. That is purely just whether or not at the pleading stage that rule is complied with. But as Pledger, I think, quite clearly shows, the Rule 9J, North Carolina's Rule 9J would not apply in federal court, which is what the lower court found. And so that issue can be easily dispensed with. The other ones are all wrapped up in the facts. Certainly the sufficiency of the evidence arguments are wrapped up in the facts. Qualified immunity, the only part of qualified immunity that's ever been an issue in this case is the substantiality of the evidence. So again, wrapped up in the facts. The exhaustion of remedies and the statute of limitations issues are wrapped up in when Mr. Moreno was conscious enough of his injury to raise things, and whether or not, as a factual matter, he had the opportunity to exhaust any sort of administrative remedies. So all of these things, digging back deep into the record, are tied up in facts that bring it outside of this court's jurisdiction. Certainly, if the court reached any of those, we've got arguments in the briefing, and we can stand on the briefing as to why the court was right to deny the motion to dismiss and deny summary judgment. But we think the proper issues before the court all came in at trial.
Thank you, Mr. Whalen.
Thank you, Your Honors.
Ms. Wood, you reserved some time on your cross appeal, so if you want to come up and say a few words about that. Or not.
I will, thank you. To revisit the issue of Rule 9J, which Mr. Whalen acknowledged is a legal issue. The complaint in this case, by all accounts, does not include a Rule 9J certification. However, in North Carolina, even despite pledger, because of the manner in which Rule 9J is applied and interpreted as a substantive rule, we do not believe that pledger guides the analysis here. I touched on that in my initial argument, but just to revisit and wrap up the argument, Rule 9J in North Carolina is a pre-filing expert witness certification requirement that requires the plaintiff to obtain an expert witness prior to the filing of a lawsuit who is one, reasonably expected to qualify, and two, who has reviewed all the records and will testify, is expected to testify, that the defendant breached the applicable standard of care. And in this case, the complaint squarely alleged medical negligence. It involved squarely the care of not just Dr. Balsham, but many other, multiple other defendants, nurses, other providers in the case. The complaint, though, as Mr. Whalen, the claim involved, as Mr. Whalen explained, an alleged failure by various providers to monitor Mr. Moreno over a 3-day period. It therefore was a medical negligence claim subject to the North Carolina substantive law. Rule 9J, and we have briefed these issues at length in our brief, but Rule 9J, although it is a North Carolina rule of civil procedure, it has been applied over the years as a substantive rule. And for example, in this case, there's no question that Dr. Balsham was a physician, and plaintiff alleges she had that duty to ensure and provide proper medical care to her patients. And going further, under North Carolina law, a plaintiff who's attempting to allege a medical malpractice claim has to include this assertion, and if it's not included in the complaint is dismissed. And it's not in the complaint, and for that reason, that is a legal issue. And the reason it's been used, one of the reasons behind the intent and the use and application of Rule 9J involves the fact that discovery is done in a case, if discovery reveals that a complaint may facially comply with Rule 9J, but in reality does not, that prompts a Rule 9J motion to dismiss, which is squarely a substantive issue involving whether or not this expert qualified, whether or not this expert was willing to testify that the standard of care was breached, and so forth. So Rule 9J should have been included in the complaint in this case, and the complaint should have been dismissed at the very beginning
at the Rule 12b-6 stage over 4 years ago, before we got to trial, at which point Dr. Bilbray still did not have any specific testimony specifically as to Dr. Bolsham. So for these reasons, we respectfully request that the denial of the Rule 12b-6 motion, that be reversed, and we further request that the dismissal and the granting of the judgment as a motion for judgment as a matter of law be upheld. Thank you.
Thank you, Ms. Wood. We'll come down and agree counsel. We thank you for your arguments and adjourn court for the week.
This honorable court stands adjourned, sine die. God save the United States and this honorable court.